and welcome to our listeners today. I'd like to introduce my colleague, Alec Karasik, one of our four speakers today. He's a member of our EEOC litigation team and has been defending government enforcement litigation for over a decade. Welcome, Alex.
Thank you, Jerry. Glad to be here today. I'd like to introduce Greg Tsonis. Greg is a partner in our Chicago office who regularly defends EEOC lawsuits. Greg is also a contributor to our Duane Morris class action review, and as well as our blogs. Welcome, Greg.
Thank you, Alex. Next up, we have Jennifer Riley. Jennifer is a partner in the Duane Morris Chicago, Los Angeles, and San Francisco offices, and she's also the vice chair of our class action defense group. Jen's also the co-author of the class action review and the EEOC litigation review, and she has defended companies facing government enforcement actions for more than 2 decades and regularly defends against EEOC pattern and practice lawsuits across the country.
Thanks, Greg, so much. It is a pleasure to be here. We are going to start off our program today by hearing from Jerry, who chairs the Duane Morris Class Action Defense Group. Jerry has confronted and defended some of the largest and most complex EEOC cases ever filed against corporate America. This includes the largest ever systemic action ever filed in the history of the EEOC, called EEOC versus Sterling Jewelers, which Jerry defended and settled for no money. Jerry also led our defense team in EEOC versus Kaplan, where we won on summary judgment at the district court level and then prevailed in the Sixth Circuit. This is one of the EEOC's most famous losses in a nationwide systemic case. The Wall Street Journal called the Sixth Circuit's ruling the opinion of the year. Jerry has probably handled and defended more EEOC lawsuits than any other lawyer in the United States. The EEOC notably has also asked him to speak at its annual training program for EEOC lawyers. So it's a pleasure to have Jerry with us on our panel today.
Thanks so much, Jen. Here's our ambitious agenda for our 30-minute session with you today. We're going to talk about 4 topics which we think are key to what's going on in the EEOC today. If you summed it up, I think the watchwords are that change is now the new normal. We're going to talk about the filings that were made in fiscal year 2025. That's a period of October 1, 2024 to September 30, 2025. And we're going to analyze those lawsuits and what employers can learn from them and how it impacts what's going on with the EEOC's stated strategic plan and priorities, and now in effect what has occurred given the impact of the Trump administration. So with not further ado, we'll start out with Jen on those case filings.
Thanks, Jerry. So this slide shows the EEOC's filing activity over each of its past 5 fiscal years. The EEOC's fiscal year 2025 spanned from October 1, 2024 through September 30, 2025. Unlike other fiscal years, the EEOC started this year strong, peaking with 14 lawsuits in January. Filings then slowed until summer when we saw a resurgence with another 14 lawsuits filed around June 2025. Thereafter, consistent with prior years, lawsuits then dipped until the 11th hour in September when the EEOC filed its signature bulk 35 lawsuits in September of 2025. So comparing these filings to previous years, the EEOC filed significantly fewer lawsuits in 2025 than it filed in 2024 at 94 in 2025, 111 in 2024, and it also filed fewer than it filed in fiscal year 2023, where it had 143 lawsuits, signaling kind of a downward trend in EEOC enforcement activity.
So in looking at the EEOC at the national level, we can really view the EEOC's enforcement activity similar to the way that we view real estate. Location, location, location is everything when it comes to analyzing the filings and litigation trends of the EEOC. While we often view the EEOC as an it because it's a single governmental agency, when it comes to enforcement actions, a more apt term may be they, given that the EEOC operates through a series of district offices that can vary in terms of the case types that they pursue, priority focus areas, and the number of filings that they pursue each year. In addition to tracking the total number of filings, we closely monitor which of the 15 district offices the EEOC has have been most active in terms of the filings each year. Some districts tend to be more aggressive than others, while some focus on different case filing priorities.
As Greg mentioned, some districts are more aggressive than others, and those two districts that lead the pack year after year in terms of EEOC lawsuit filings tend to be Philadelphia and Chicago. Last year, Philadelphia had 14. This year, there's a slight drop to 11 lawsuit filings. Chicago had 11 both years, and these two tend to be head and shoulders above the others. Two districts that increased their lawsuit filings were St. Louis, which went from 2 to 5, and Phoenix, which went from 4 to 7. Two districts that went down in terms of lawsuit filings were Atlanta, which dropped from 11 to 7, and Indianapolis, which dropped from 11 to 8. The key takeaway here for employers is that you have operations in Philadelphia or Chicago and you get an EEOC charge. Those locales were the most likely to see those charges turned into lawsuits.
We also track types of lawsuits. What is the bread and butter of what the EEOC files? And as this chart shows, clearly disability cases, gender discrimination and retaliation are the three leading causes of action that represent the lawsuits filed by the EEOC. If we were talking about 10 years ago, over 50% of these cases would be on behalf of groups of employees called systemic cases. Now, nearly 80% of the filings are what are called onesies or twosies on behalf of one or two employees, very targeted at either small employers or very large employers. And the EEOC is trying to allege retaliation and disability probably more than anything else. Why? Because those are the two causes of action. They're probably the most impervious to a motion for summary judgment. And those are the theories that the EEOC typically has the most success on in litigation. I think the most vexing problem for HR professionals tend to be discrimination cases based on disability and providing reasonable accommodations, especially with respect to mental related disabilities, depression, post-traumatic stress syndrome, things of the like. So it doesn't surprise us that disability continues to be the leading cause of action brought by the EEOC. You'll see there are no filings with respect to gender identity or sex orientation. That is the hand of the Trump administration, de-emphasizing that particular cause of action that first arose during the Obama and Biden administrations, where the EEOC was an active filer in that particular space.
Now let's look at the breakdown of EEOC lawsuit filings by statute. Title VII cases, once again, made up the majority of cases filed. They constituted about 50% of all filings in fiscal year 2025. That's down from about 58% of all filings in fiscal year 2024. Overall, ADA cases made up the next most significant percentage of the EEOC's filings in 2025, totaling 31.5%. Now, that is an overall decrease compared to prior years. ADA filings made up 42% in fiscal year 2024, 34% in fiscal year 2023. In 2025, we also saw an uptick in ADEA filings. Those are filings under the Age Discrimination in Employment Act. The EEOC filed 9 ADEA cases in 2025 compared to only 6 in 2024. This past year, interestingly, the EEOC also filed 6 cases under the Pregnant Workers Fairness Act compared to 3 in 2024. In addition, the EEOC filed slightly more lawsuits under the Pregnancy Discrimination Act, with 5 cases in 2025 compared to 4 in 2024. Notably absent from the pie chart in 2025 are cases filed under the Equal Pay Act or the Genetic Information Non-Discrimination Act. Those are 2 areas that the EEOC has repeatedly cited among its enforcement priorities.
But we also look at the EEOC's lawsuit filings in terms of the industries that they may choose to focus on from year to year. And so in fiscal year 2025, two industries remained in the EEOC's crosshairs: hospitality and healthcare. On a percentage basis, hospitality, which includes restaurants, hotels, other entertainment venues, comprised a quarter of the filings, and healthcare had 21.3% of filings. One of the key differences that we see in fiscal year 2025 as compared to 2024 is the relative prioritization of manufacturing versus retail. So in 2025, the manufacturing filings were 15% of cases, whereas that was only 12.1% of the filings in 2024. Retail, comparatively, was only 11.3% of cases in fiscal year 2025, as compared to 23.1% of the 2024 filings. And so those are the next two most targeted industries, but the staggering drop in enforcement actions against retailers is a distinct drop in enforcement actions, and in turn, the relative prioritization of that industry with respect to the EEOC. Otherwise, only one other industry, transportation and logistics, entered double-digit enforcement activity with about 10%. The remaining industries in fiscal year 2025 didn't enter even double-digit percentages in terms of the filings, though staffing and construction each experienced EEOC-initiated litigation and were each about 8.8% respectively.
Next two slides demonstrate what a profound impact the recent presidential election had. This is a summary of what the EEOC had adopted 2 years ago, its 4-year strategic plan, where it put down on a piece of paper how it was going to spend the taxpayer dollars. And if there was one theme with respect to that strategic plan, it would be that the EEOC would try to get the most bang for its buck by bringing the largest cases possible, called systemic actions, which would send a message to an industry and would impact the greatest number of people. And so it would invest in training its staff on identifying and investigating systemic discrimination, and it would increase its attorney arm out in the field to prosecute those cases. It's one thing to put it on a piece of paper, it's another to see what's going on in practice. This has been scrapped insofar as the Trump administration has started, and so the numbers bear out that the filing of systemic actions really has been downplayed and is not the main focus of emphasis by the EEOC anymore. This is a very interesting slide insofar as in the Biden administration, the EEOC adopted 6 priorities with respect to how it would enforce anti-discrimination laws. It was known as the SEP, Strategic Enforcement Plan. And I'd have to say that the EEOC was pretty much aligned with these 6 areas, and every lawsuit kind of sorta would fall into one of these categories. So you saw more than ever before lawsuits based over onboarding, the recruitment and hiring of people, which may be low damages cases, but the theory was that opens up lines of employment for people who are unemployed. At the other end would be the prevention of systemic discrimination, especially workplace harassment. And in between would be lawsuits on behalf of vulnerable workers, cutting edge issues, equal pay, and retaliation cases. I think you can put these all in the mix now and say really the area that the EEOC is focusing on the most would be systemic harassment in terms of sex harassment, and preserving access to the legal system in terms of retaliation cases. It may well say on paper that it's focused on equal pay, but the number of lawsuits one could count on one hand. And the third priority in terms of developing case law and cutting edge issues that has been abandoned by the Trump EEOC, as well as the protection of vulnerable workers. So what does the future hold in store? Difficult to say. That's why the theme of today's webinar is kind of change is constant, and you're certainly seeing it at the EEOC level.
The EEOC's annual performance report, which spans 78 pages this year, essentially functions as a scorecard where the commission publishes data and statistics that can show how they use the taxpayer dollars to enforce anti-discrimination laws. This year in the January report that was published, the EEOC touted some impressive numbers, recovering nearly $700 million on behalf of 21,000 individuals and resolving 132 merits lawsuits. What will be interesting to see is next year's APR and whether those numbers come close to that, given that the Commission has been filing significantly less lawsuits in the recent months and over the past year. One number that may not go down is the Commission reporting that it received 88,531 new charges of discrimination. The EEOC has been focused on making filing charges more accessible, and with the advancements of technology, this number, there's no reason why it shouldn't continue to increase year after year.
So in the scorecard Alex just mentioned, the EEOC reported that it resolved 16 systemic cases in fiscal year 2024, which resulted in securing $23.9 million for alleged victims of discrimination. That represents actually a $12.2 million increase over fiscal year 2023. In fiscal year 2025, of the 93 lawsuits filed, 14 were systemic suits. This is fairly consistent with what we have seen over prior years. It's 1 higher than 2024, 11 fewer than 2023, but 2 higher than 2022. In terms of those filings, there are a couple notable examples of what the EEOC has filed. First on the slide, EEOC versus Venetian Las Vegas Gaming. In that case, the EEOC reached an $850,000 settlement to resolve allegations that the resort refused to accommodate religious beliefs in violation of Title VII. In the second case there, EEOC versus Bell South Telecommunications, the EEOC filed suit claiming that the employer discriminated against workers whenever they exceeded a 275-pound weight limit in violation of the ADA. Then in the third case there, EEOC versus Carl Star Group. That's one of 4 recent lawsuits the EEOC filed accusing employers of violating the ADA by discriminating against workers, either because they take prescribed opioid medications or because they are receiving treatment for past opioid use. Now, here looking at those systemic investigations resolved by year. So we talked about lawsuits a second ago. This slide shows investigations. The graph on the left shows the emergence and growth of the EEOC systemic investigation program over the years. It depicts the number resolved year over year from 2006 onward. In 2006, you can see the EEOC resolved only a handful. And then through the present, you can see that the number exceeded, dipped, and then has climbed back to around 400 systemic investigations per year. The graph on the right shows the monetary relief the EEOC obtained in connection with these systemic investigations, which, setting aside some of those spikes in 2012, 13, 2015, 2017, that number has fairly steadily increased over the past 2 decades.
In terms of the systemic lawsuits that Jen talked about, the one star caveat is most of those were filed while President Biden was still in the White House. With Donald Trump in the White House, there's been a downshift and less of an emphasis in it. A few have been filed, but not very many. I used to get a call once a week from General Counsel about systemic investigations with which they were involved, and the amount of those investigations are going down. The amount of money being recovered is going down. And this is an area where it remains to be seen whether or not the Trump administration's EEOC will get back in the business of what for the last 25 years the EEOC focused on as one of the most important areas. One of the manifestations of this was the EEOC adopting a policy that as of September 30, 2025, it would no longer use a disparate impact theory to bring cases or lawsuits on behalf of individuals. And most systemic cases, not all, but most, had a tie to the disparate impact or adverse impact sort of theory. So the fact that the EEOC is abandoning and peeling back its use of that tool is one signal that to the extent there are going to be systemic cases, there are going to be less of them. Interestingly, earlier this week, a lawsuit was filed on behalf of an Amazon worker claiming that the EEOC's decision to abandon disparate impact theory cases was a violation of that person's rights. It was actually brought by one of the ex-general counsels of the EEOC, and it remains to be seen whether or not that lawyer will be conflicted out and whether or not the court will recognize some sort of cause of action in that area. But I think it underscores how controversial it is, what a shift it is, and how it's a different way of doing business. I think one of the unknowns here is what will the EEOC do when it appears before Congress? Inevitably, like most agencies, it asks for more money for its budget in years. And one of the exhibits it always used in asking for a budget increase was the cost of prosecuting systemic discrimination cases. And if the EEOC is going to get out of the business of doing so, query what will that mean with respect to the exhibits they're going to use or the arguments they're going to use as to why their budget should be increased rather than decreased. So change is in the air in terms of everything involving EEOC systemic lawsuits.
So in terms of strategic priorities, artificial intelligence is certainly one. This slide has a summary of a case called Mobley versus Workday. This is a prime example of a case to watch where plaintiffs are seeking to hold a software vendor liable for the use of its products by others. In this case, it was filed in the Northern District of California. The plaintiff was an African-American male over the age of 40 who claimed that he suffered from anxiety and depression, and he brought a lawsuit against Workday, claiming that its applicant screening tools discriminated against applicants on the basis of race, age, and disability. The plaintiff claimed that he applied for 80 to 100 jobs, and despite holding a bachelor's degree in finance, among other qualifications, he did not get a single job offer. Workday, of course, is a software vendor. As I mentioned, the district court therefore initially granted the motion to dismiss, finding that the plaintiff had failed to plead facts regarding Workday's supposed liability as either an employer or as an employment agency. In other words, the plaintiff failed to allege that Workday was procuring employees for its customers and merely claimed that he applied for jobs with a number of companies that all happened to use Workday. In February 2024, the plaintiff, though, filed an amended complaint alleging that Workday was an agent of the employers that delegated authority to Workday to make hiring process decisions, or alternatively, that Workday qualified as an indirect employer. That complaint withstood the motion to dismiss. And then interestingly, the EEOC in April of 2024, I should note, filed an amicus brief in support of that plaintiff and in opposition to the motion to dismiss. The EEOC in that brief described Mobley as a case that implicates whether Title VII, the ADA, the ADEA cover entities that purportedly screen and refer applicants and make automated hiring decisions on behalf of employers using algorithmic tools. As I mentioned, again, the amended complaint withstood the motion to dismiss, and then a few months later, the court granted conditional certification of that case, effectively allowing the plaintiff to provide notice of the lawsuit to individuals over 40 and who applied using Workday's platform and were denied employment. The court reasoned that the allegations really center on a common question as to whether the AI recommendation system has a disparate impact on applicants over the age of 40. Again, as I just said, the judge based her decision largely on the disparate impact theory. That is significant because, as Jerry just mentioned a moment ago, President Trump signed that executive order directing federal agencies, including the EEOC, to refrain from enforcement activities based on the disparate impact theory. That move almost certainly will reduce government-led investigations into algorithmic discrimination based on a disparate impact theory for the foreseeable future, at least, but it does not impact necessarily private litigation like the Workday case, and will likely actually prompt the plaintiff's bar to take up the charge and file more of these disparate impact cases on its own.
So with every new presidential administration, there's very often a shift in the array of objectives that administration wants to focus on, and different policy priorities that they like to implement and focus on as well. And that has held true with the current administration. Since President Trump has taken office, however, he's taken unique steps to reshape the commission by firing its acting chair or its chair, two of the commissioners of the EEOC, and its general counsel, all within the course of a few weeks. Kalpana Kotegal remains a commissioner as she was designated by President Biden in July of 2023 for a term that expires in July of 2027. And since the Trump administration has been in place, on January 21st, 2025, President Trump appointed Andrea Lucas as acting chair. On February 4th of this year, Andrew Rogers was named as acting general counsel. And just a couple of weeks ago, on October 7th, Brittany Panuccio was confirmed by the Senate as an EEOC commissioner, restoring a quorum. So with a quorum now restored, at the EEOC, we expect to see some movement. Notably, we expect that the EEOC will move to replace its current harassment guidance, which was issued in April of 2024. In May of 2025, federal court vacated certain portions of that guidance with respect to sexual orientation and gender identity. Specifically in Texas et al. Versus EEOC, the district court held that the EEOC's guidance contravened Title VII by expanding the definition of sex beyond the biological binary, to use the court's language, and secondly, by, quote, requiring employers to accommodate an employee's dress, bathroom, or pronoun requests, close quote. So we expect, in addition to the several executive orders that Alex will talk about, more change on that front.
Yeah, thanks, Greg. As Greg noted, the EEOC's shift in priorities probably starts with their focus on DEI. The DEI focus probably started with the President Trump's executive orders that were issued in January 2025. One quick observation: when you're watching this webinar next year, it'll be interesting to see whether there are any DEI-related lawsuits filed. As Jerry mentioned, there's a void of lawsuits involving gender identity or sexual orientation discrimination. But one thing that we're going to be paying close attention to is whether there's any lawsuits filed involving discrimination that's somehow tied or related to DEI practices.
Greg, could you talk about that shift and what it's done with lawsuits and settlements?
Of course. So the EEOC filed only 3 race or national origin lawsuits in fiscal year 2025, a substantial drop from the 14 that were filed in fiscal year 2024. Of those 3 lawsuits, 2 of them were based on claims of anti-American discrimination. So in EEOC versus Seward and Son Planning, which was a case in federal court in the Northern District of Mississippi, the EEOC ultimately struck a $150,000 settlement with a Mississippi farm operator to resolve a suit brought under Title VII for race and national origin discrimination, alleging that the employer disfavored agricultural workers who were Black and American. That was one of the notable pattern or practice filings that was reported on in the media. And the announcement of the first 7-figure EEO settlement since President Trump took office was in another case, EEOC versus Leo Palace, which I think is a clear example of the agency's commitment to anti-American bias enforcement. So in that case, the EEOC settled a lawsuit and entered into a 3-year consent decree. The hotel operator agreed to pay over $1.4 million and hire an outside monitor to settle allegations that it provided non-Japanese employees with less favorable wages and benefits. And that was accompanied by a statement from Acting Chair Lucas announcing the new enforcement agenda and the intent to protect all workers from national origin discrimination and anti-American bias.
All right, now let's wrap up with gender identity. In February 2025, citing the Trump administration's executive order on gender ideology extremism, the EEOC announced it would withdraw 7 lawsuits it had filed across the country, including 3 in Illinois. Then in May 2025, a Texas federal court held that the Biden EEOC's expansion of the definition of sex in its enforcement guidance on harassment in the workplace was contrary to law, and as a result, vacated portions of the EEOC's guidance nationwide. That guidance is available in redacted form on the website. Among other things, the definition of sex continues to include pregnancy, childbirth, and related medical conditions, but now it strikes sexual orientation as well as gender identity.
Well, I think what you saw is change that you've never seen it before with the EEOC withdrawing those lawsuits. We talk all about it in our EEOC litigation review. The price is perfect. It's free of charge. You can download it off our system or this QR code. So thank you very much for being with us. We've enjoyed spending a quick tour of the EEOC. You can get these materials off our blog and our website. And we thank you so much for joining us today. Have a great afternoon.